Hello and welcome back everyone. Today we dwell into a crucial aspect of property law in the UK, the Landlord and Tenant Act 1954. Now this landmark legislation has shaped the commercial property landscape, providing essential rights and obligations to both landlord and tenants. So in this video we will explore the key provisions of Landlord and Tenant Act 1954 and also aiming to provide you with a comprehensive understanding of its significance. So let's get started. Let's now see what security of tenure is as defined in the Landlord and Tenant Act 1954. So it refers to legal protection provided to business tenants regarding the renewal of their leases. This provision ensures that the business tenants have the right to remain in the premises after the lease has expired, so subject to specific conditions and grounds set out in the Act. Now, security of tenure is especially important for businesses that have invested in the location and want the stability of knowing that they can continue operating from the same premises. Now, there are key aspects of security of tenure which are automatic right for renewal. So under the Act, business tenants have automatic right to renew their leases when it comes to an end. Now, this renewal is not dependent on landlord's consent. The tenant have a legal entitlement to request a renewal. Similarly, there is a renewal terms when renewing the lease. The terms are negotiable, but they should be in line with the existing lease terms under unless both parties agree otherwise. So this includes factors like rent, duration, and other lease conditions. So in summary, a tenant benefits from the stability and continuity the Act offers, while the landlord follows the proper legal procedures if they intend not to renew the lease. Grounds for termination. So the Landlord and Tenant Act 1954 provides a framework that outlines certain conditions under which the lease can be terminated. For example, non-payment of rent. So if the tenant consistently fails to pay the rent, it can be ground for termination. However, the landlord must follow proper legal procedures and provide legal notice to the tenant. Similarly, breach of lease terms. So if the tenant breaches significant terms of the lease agreement, such as damaging the property or using it for illegal activities, the landlord may have grounds for termination here. Other than that is tenant's voluntary surrender. So if the tenant is willingly agree to surrender the lease, the landlord can terminate it. Other than that is end of lease term. So if the lease reaches its natural end, the landlord does not need specific grounds to terminate the lease. However, proper notice may still be required. Landlord's intention to occupy or sell the property. So if the landlord intends to occupy the property themselves or sell it, they might have grounds to terminate the lease. This is subject to procedures outlined in the Act, of course, including proper notice to the tenant. And the last is the redevelopment of the property. If the landlord plans to redevelop the property and the lease hinders the redevelopment process, they might be able to terminate the lease. So these are some conditions under which there are grounds for. Let's now see what is compensation and renewals in Landlord and Tenant Act 1954. Now, compensation is again divided into two: compensation for improvements and compensation for loss. So, under compensation for improvements, the tenant have the right to claim for compensation for improvements made to the property if they are forced to leave the property at the end of the lease. So this compensation is based on the value the improvement add to the property. While on the other hand, compensation for loss is when if the tenant is forced to leave the property at the end of the lease and the landlord's refusal to renew the lease, they might be eligible for compensation for the loss incurred as a result of the move. While lease renewals, to renew a lease, the tenant must follow renewal procedures outlined in the Act. Now, this includes serving proper notice to the landlord, following legal timelines. Now, we have already touched on security of tenure and ground for termination. So, the Act provides a specific set of grounds that are considered as a valid reasons for non-renewals. Let's now first see what is statutory tenancy. A statutory tenancy is a tenancy where it is protected under the Landlord and Tenant Act 1954. Now, statutory tenancies provides a security of tenure to the tenant. This means the tenant has a legal right to renew the lease at the end of its lease term. Also, to terminate the lease or oppose its renewal, the landlord must serve a formal notice to the tenant and specifying the grounds for non-renewal, and also follow procedures outlined in the Landlord and Tenant Act 1954. On the other hand, a non-statutory tenancy, also known as excluded tenancy, refers to the lease that falls outside the protection of Landlord and Tenant Act 1954. Now, this tenancy do not provide the tenant with any automatic rights to renewal or statutory protections. Non-statutory tenancies do not require the landlord to follow the procedures for terminations. Instead, the terms and conditions for terminations are determined by the lease agreement signed between the landlord and tenant. Renewal process, eviction process, or other procedures, other aspects of tenancies are all governed by the lease agreement. So finally, we have come to the end of this video. To summarize, the Landlord and Tenant Act 1954 plays a crucial role in shaping the relationship between the landlord and tenant in a commercial properties. So understanding the provisions of this act is essential for landlord and tenant to ensure that a legally sound business environment is provided. So thank you for watching this video. I hope this video has provided a valuable insight in the Landlord and Tenant Act 1954. So don't forget to subscribe for more such real estate content. Thank you.